Court Master, please begin.
Thank you, Rithi. A very good morning to all of you present here. I hope I am perfectly audible and visible.
Yes.
Welcome to the courtroom of the, thank you, sir. Welcome to the courtroom of the final round of the second ALI National Moot Court Competition 2022, organized by Law Internships, the online law school. I am Manishita Bhattacharjee, the court master for this courtroom, along with me Ashmita as a timekeeper. I would like to invite our judges present here virtually who have took out their time from their busy schedules. Number one, we have amongst us Honorable Dr. Justice M. Jayachandrana, former judge of Madras High Court. He was elevated as a judge of the High Court of Madras in the year 2005 and retired in the year 2017. He was an international visitor to the USA as a guest of the United States government on issues relating to human rights. He was the President, Board of Governors, Tamil Nadu State Judicial Academy, and conducted numerous international, national, and regional conferences, seminars, and workshops. Currently, he is designated as Senior Advocate of Supreme Court of India. We welcome you in our competition, sir.
Thank you.
Next, we are having Honorable Mr. Justice Vijay Chaganial Daga, former judge of Bombay High Court. He was an advocate who, after his enrollment, he established a practice in civil, constitution, labor, banking, service, and excise matters before the Nagpur bench of the Bombay High Court and various other jurisdictions. Currently, he is designated as Senior Advocate of Supreme Court of India. We welcome you here, sir.
Okay, thank you.
Next, we have with us Mr. Pradeep Rai. He is a senior advocate and vice president of the Supreme Court Bar Association. Mr. Rai has over 2 decades of standing at the bar in the Supreme Court of India, various high courts, commissions, regulatory bodies, and tribunals. He has experience in litigation across a wide spectrum of civil, criminal, revenue, and constitutional issues. Mr. Rai is also the chairman of India Legal Aid Center and the chairman of India Legal Research Foundation. It's a moment of extreme pleasure to have you here with us, sir. Next, we are having with us Mr. Siddharth Nayak. He is the founder and managing partner of Atharva Legal LLP, a full-service law firm having its presence across 6 cities in India with a diverse practice in all domains. Mr. Siddharth Nayak has extensive experience of handling matters of diverse nature and across various fora. Inter alia, Supreme Court, High Courts, National Green Tribunal, National Company Law Appellate Tribunal, National Company Law Tribunal, Debt Recovery Tribunal, District Courts, and other tribunals, judicial authorities. We welcome here Mr. Siddharth Nayak. So, next we are having Mr. Naveen Kumar Murthy. He is the founder of NKM Law Chamber and a qualified practitioner focusing on litigation, arbitration, and corporate advisory, and has dealt with wide-ranging matters in the areas of corporate law, insolvency and bankruptcy law, arbitration, constitutional law, environmental law, securities law, civil and criminal laws before the Supreme Court of India, Madras High Court, Kerala High Court, Bombay High Court, and etc. We welcome here Mr. Naveen Kumar Murthy. So, next we are having Ms. Simran Rar. She is an advocate and a partner at Karan Jawala and Co. Company advocates. She has over 17 years of extensive experience in civil commercial litigation, telecom disputes, and arbitration. She is a graduate of Campus Law Center and St. Stephen College, University of Delhi. We welcome you, ma'am, here. Now, I would like to request each participant to keep their camera on all the time. My lordship and ladyship, I would also request you to turn on your camera if you are comfortable. I hope everyone has checked their respective audio and videos and are audible clearly. So, with the permission of the court, can I start the session?
Yes.
Yes.
Thank you so much, sir. So team code 2 is the side of the petitioner and team code 4 is the side of the respondent. Speaker 1, speaker 2 and researcher of the team 2 and team 4 all are present. Kindly confirm.
Yes, ma'am.
Thank you so much for confirming. Let me remind you all the rules and regulations once again. It is a knockout round, which means only one team will be qualifying, and the total time of the round is 60 minutes. Participants are not allowed to disclose their personal identification in the round, even if asked by the judges. Time instructions will be given by the timekeepers via Zoom's chat box, and all the participants are requested to keep a note of it. Total time allotted is 15 minutes per speaker, which is inclusive of the rebuttal and sur-rebuttal round. And the total time of the round is 60 minutes inclusive of rebuttal and sur-rebuttal round. We wish you all the very best for your round. The side of the petitioner can start.
Yes.
The council seeks permission to initiate the proceedings.
Yes.
Much obliged. Greeting to the honorable bench. If I may please the honorable court, the council is deeply honored in appearing to the court on behalf of the appellant in the case of Islamia Karimia University and others versus State of Tatooine and others. With the consent of the ladyship, may the council collectively address the bench as your lordships.
Yes. I think yes.
Much obliged, your lordships. I'll be speaking for a total of 15 minutes and dealing with the first two issues, and my co-counsel will be speaking of total of 15 minutes and dealing with the other two issues. Much obliged, your lordships. If your lordship is well versed with the facts, may the council seek permission to present the arguments of the present case.
Yes.
Much obliged, your lordships. Under the contention was in the present case, whether the minority educational institutions have an absolute right in their favor under Article 29 and 30 of the Constitution of my chain. The petitioner humbly submits before the Honorable Supreme Court that educational minority institutions have an absolute right in their favor under Article 29 and 30 of the Constitution. The petitioner submits various contentions to prove the same, that banning of hijab by the state government of Tatooine was violative of their fundamental rights, where subpart A states that Article 29 and 30 guarantee and protect the cultural rights of the minorities. Article 29 states there is protection of interest of minorities. In the case of Bal Patel versus Union of India, it was debated whether Jains could become a minority under Section 2C of the Minorities Act. The court rejected the claim and stated that it is a statutory duty, and therefore, before the central government could take a decision on the claims of Jain, it was stated that it could be identified on the state basis. Supreme Court pointed out in the case of Ahmedabad St. Xavier's College versus State of Gujarat that the spirit of Article 30 Clause 1 is consciousness of the nation that minorities, whether religious or linguistic, are not prohibited from establishing and administrating educational institutions.
Madam, there is no, madam, I'll just stop you for a minute. There is dispute with regard to them establishing, or we understand what a minority is. The question now that you have to address is twofold. One is with regard to the validity of wearing a hijab. Likewise, where one high court has held against you, and the other part where the other high courts have held in favor of the headscarves and in favor of the Jains. So you have to demonstrate to us on what ground you want the 7-judge bench to interpret.
So there is a presumption that you are a minority institution, though minority is not defined in the Constitution. Has it been defined in the Constitution? No.
Sir, according to the case of re-education bill, it was stated by the Supreme Court that minority is a community which is numerically less than 50%
Madam,
of
please
the
understand one thing. What the Honorable Senior Judge has asked is minority, has it been defined under the Constitution? Has minority been defined, saying that this is minority? Has it been defined?
Or in any of the international conventions or covenants?
Pardon, sir?
No,
Has the term minority been defined, madam? Has it been defined in the Constitution or any other international convention, as his lordship asks?
Sir, it is stated in the Minority Act, saying that the central government will be the person deciding whether the institution is minority or not.
Council, the question was, has this term minority been defined in the Constitution of India? Or
No, sir.
no?
So where do you get the meaning of the word minority?
Did you hear the question?
Yes, your lordships.
Please answer.
So we basically what we understand by the meaning of minority is through the case which I earlier quoted, that it is the population which is less than 50% of the total population. So if we see in our memorial also, we can see that.
Madam, it is not, I'm sorry. It's not your understanding what Honorable Justice Daga lordship has asked. Is how do you figure out how do you say what is a minority? As the Supreme Court defined, stating that these categories would be minorities, if at all you're having any judgment where the Supreme Court has defined what would be a minority on what context, is there any judgment you're relying upon?
Because your entire foundation of your arguments will be based on the fact that you're a minority institution, right?
Yes, sir.
So please answer that question, what learned judge has asked.
On what footing a community is declared as minority? That is the question. All right,
if you can't answer, you leave it to your co-counsel to answer if she can.
You can proceed if you.
Counsel, you can come back.
So I would like to say that Article 29 and 30 does not clearly specify minorities in India, but it states that there are linguistic and religious minorities in
Counsel,
India.
there is no doubt about it. We had a very specific question. Where is minority defined? If it is not defined, has the Supreme Court told what a minority is?
Sure, sir. Sure.
We'll come back to it.
Counsel, meanwhile, you can seek instruction from your researchers to get back to us over this specific query.
Sure, Lordship. So, what basically the ground for the community to be nominated as a religious minority, or it is basically dependent on the numerical strength of the community. If that community is having a less percentage in the population, then we can say that it is a minority. But I don't have any case to quote over here. But according to my understanding, it is the strength of the population which considered, if that pleases the honorable bench.
All right, proceed.
Much obliged, your lordships. So Article 31 of the Article 31 Clause 1 gives the linguistic and the minority educational institutions two rights, that is right to establish and right to administer their educational institutions of their choice. It was clearly stated in the case of Ray Siddharth Bhai. A bench of Supreme Court observed that the minority education shall be valid only if they satisfy a dual test, which makes the minority institution more effective.
Is the right of these minority institutions absolute, or is it can be restricted to a reasonable extent, and on what grounds?
Sir, it's not an absolute right, but the state can only interfere in the cases when there is a case of maladministration. If there is no issue in the institution of related to maladministration, the state may use steps to control that rather than taking the control over the whole institute.
For maladministration or for the sake of excellence of education? The ground mentioned therein, is it for maladministration in the article, or is it for the excellence of education? What you just referred to now.
Yes, sir.
On what ground on what ground can the government, now the government has passed an order. So on what ground is the validity of the order is being questioned, right? So whether it is for health or morals or public order, or is it for excellence of education?
Sir, it is for
Maladministration. Where is the question of maladministration arising here?
Which regulatory measures will violate Article 30?
sir, pardon.
Which regulatory measures would constitute an infringement of Article 30?
Sir, if the education institution is being discriminated in any of the sense, like if there is a difference being created.
Madam, I think you've not understood the question. What Honorable Justice Jayachandran and Justice Daga have asked. What they asked is, the state has the right to interfere in certain matters, even if you claim it to be an absolute right. When can the state interfere, and on what grounds will the interference of the state be unconstitutional or impermissible? State can interfere to maintain excellence of quality of education, correct?
Yes,
a minority institution cannot claim, no, I will not maintain quality of education. State
Yes,
can
sir.
have the right to say you will have to maintain excellence in education. That is the question that was asked to you.
Yes, sir.
Yeah, because you say it's not an absolute right. So therefore, the state can interfere on the ground of excellence of education, right?
Yes, sir.
All right. Yeah, see. You can proceed, ma'am.
Yes, proceed.
Much obliged, Your Lordships.
Counsel, what are the two issues you are addressing?
Sir, I'm addressing issue number 8 and issue number B.
I think your mic is not clear. Yeah, yes.
Sir, I'm addressing issue number A and issue number B.
All right.
Counsel, can you come down to page 14 of your memo?
Yes, sir.
Now, in your submissions, you have unambiguously stated that Article 30 provides you an absolute right, while few moments back you agreed that it is not an absolute right. In fact, you yourself said that there are precedents which say there are grounds for interference and it cannot be deemed an absolute right. Now, my question to you is whether you are equipped with this particular case, Indian Young Lawyers Association, you have it with you?
Um,
I'm
The
asking
2019 judgment.
Sir, actually, the voice is quite disturbing in between.
Am I clear now?
Yes, sir.
All right. So what I'm saying is you have admitted in your pleadings that you deem Article 29 and 30 to be of absolute in nature, while few moments back you agreed that it is not absolute. In fact, you yourself said that there are precedents which allow interference. Correct? But
Yes,
your
sir.
pleadings are contrary to your submissions over here.
Sir, we would say that it is an absolute, but over here there is no such case of like where there is unequal distribution of whether we can say the age which is provided or there is being any discrimination. The state may interfere in the institution only if we see that there is uneven, like unfair rights, unfair practices which are going on, whether into admitting the students or related to fees or any of these things.
All right, proceed.
Yes, carry on. Yes, carry on.
नहीं यार क्या तरीका है ये?
You can proceed. Yes, please.
Proceed, ma. You'll be spending your time.
It is hereby stated that banning of hijab by the government of Tatooine is arbitrary and violative of the fundamental rights of the minority community, and the minority education institution have an absolute right to decide on their matter. The state may intervene only in cases of maladministration in the institution, and the state cannot take over the administrative actions in their own hand to prevent the maladministration. Even Article 20.
Madam, I'll stop you for a minute. See, in a minority institution, is it mandatory that only minority students alone will be admitted, or will students belonging to the other faith be admitted?
No, sir, it's not mandatory that only minority educational students can be admitted to that, because students can take admission into the.
There is, see, a minority institution has a right to establish an institution. A minority has a right to follow their culture. But
Yes, sir.
not necessarily every minority institution will only have minority students. It will have a mix of others, correct?
Yes, sir.
So the question now is, in that case also, even if your right is absolute, shouldn't there be some uniform pattern where the clothing or the uniform dresses that they wear, there must be some uniformity in it so that there is no discrimination.
So there must be uniformity, but that does not mean it should hamper the rights of a religious community. A practice which is going on from a long time, there must be a uniformity, but not hampering the religious rights of a community also.
We're referring to Article 25, Council.
Yes, sir.
Now, do you have this particular case law with you, Indian Young Lawyers Association? Your researchers are good with the case law? The judgment passed in Indian Young Lawyers Association?
Is it part of your?
Yes, sir.
Yes, sir.
Now, I want your researcher and you to pull out para 209 and para 210 of the particular judgment and get back to Naveen, sir, over the particular point that he questioned you about. Your rights vis-a-vis Article 25 cannot be held absolute as well. Do you agree?
Madam, as my brother Siddharth says, kindly go through the judgment and come back to us. I think I have raised a query, even he's raised a query. The 2019 Indian Young Lawyers judgment, just go through it and come back to us. Maybe in the rebuttal.
It is to establish and administer. That's your right. You also admitted it's not an absolute right. So the question was whether now wearing of hijab, whether it is a matter of religion, whether it's part of religion, and whether it should be allowed. If it is banned, is that interference by the government in your right to establish and administer a minority institution?
And what is the evidence to show that it is a religion, part of religion?
Yes. That it's an integral part of religion, that you have a right to follow that in spite of the government orders.
Sir, I would say that Article 25, in Article 25 of the Constitution, the state may only intervene if there is a disruption of political, if there is disruption in the peace which is there in the public or the law and orders. And whereas we can see that hijab does not create any of this ruckus in the society. Whereas we can see that hijab is already in their holy book Quran, it is stated that it is a haram if they don't wear it. It is not completely stated that if they don't wear it, it is stated that if they don't wear it, it would be considered as haram. And they cannot carry their bodies like in a manner in which their body parts is being shown.
Madam, is that exactly what the Quran says? Is that exactly what the Quran says?
Sir,
in fact, does the term hijab occur in Quran, or does the term jiljab occur in Quran?
Sir, it occurs very less time, but we can see that.
No, madam, please just follow it up. Does the word hijab occur in Quran or jiljab? In fact, the word hijab does not. Please go through it and come back.
Hijab occurs.
Exactly. There is no hijab. Hijab is what we have created. I think from whatever jiljab, we have made it as hijab or burqa, as the case may be. All right. So exactly my question is, does Quran say that a woman should not go out without a burqa or a hijab at all? And is there any conclusive proof? Because there is interpretation. Bhagavad Gita is interpreted 100 ways, correct?
Yes, sir.
Bible is interpreted 100 ways, correct?
Yes, sir.
So even Quran can be interpreted in different ways.
Yes, sir.
So in that context, is there any judgment of the Supreme Court where we have laid down categorically stating that no, hijab is an essential religious practice, therefore it can be permitted?
Sir, I don't have any judgment which is stating that it should be permitted by the Supreme Court, but what I can see is analysis of the Quranic injunctions and hadith showed that the farz is to cover the head and wear long sleeves dress except for the part and exposing the body otherwise is forbidden. Basically, it's a choice whether you want to cover your face or not, but it is basically a compulsion type of thing that you need to cover your body at least.
Madam, 4 minutes are left. You proceed fast.
Council, just one quick question along with the researcher. Are you aware of the judgment by the Jammu and Kashmir High Court in Lubna Maharaj versus Maharajpati?
Sorry, sir, I'm not convinced with that judgment.
Already.
Just proceed.
So,
for
Yes.
Are you aware of the Kerala High Court judgment of Justice Mushtaq Ahmed? Kerala High Court. Are you aware of that, madam? Justice Mushtaq Ahmed's judgment?
so this,
In fact, maybe I can tell you even it's the judgment of Justice Mushtaq Ahmed dated 4 in the case of Fatima Tasneem. Judgment date is 4/12/2018. Judgment of Justice A. Mushtaq Mohammed of the Kerala High Court, where he has said that students cannot claim wearing hijab as a matter of right.
But para 29 is what Naveen sir is referring to. So if you go through that particular judgment, the essential question was whether hijab can be deemed as a Quranic injunction or not. That specific query was interpreted and answered in that particular judgment by the Honorable Justice of Delhi.
And to make things worse for you, I think
Sir,
you know what the recent full bench of the Karnataka High Court said.
sir, pardon, sir, I'm not able to understand because the mic is, I think, too far from when you are speaking, because some things are audible and some things are not audible.
Counsel, I said to make things worse for you, have you seen the recent Karnataka High Court full bench judgment? I think all of us have been following that proceedings all through the country.
Yes, sir.
Presumably from Delhi.
Yes, sir.
What did the full bench say? The Karnataka full bench? Madam, are you aware that the Karnataka High Court, a full bench, 3 judges?
So it stated that hijab is not an essential religious practice.
Exactly. So there are 3 judges who have told that. There is a judge of the Kerala High Court who has told that. Is
Yes,
there
sir.
any contradictory jurisprudence? I think Madras High Court has said in your favor. Any other High Court has told in your favor?
Sir, we don't have it in our favor, but still we would like the Supreme Court.
All right. How advanced is Europe compared to India culturally?
So it's
Very modern and advanced.
yes, sir. Yes, sir.
We are conservative.
Yes, sir. We are conservative, but still, sir, we have very much diversity as compared to
Absolutely,
European
no, no.
countries.
My question is specific. Europe is considered to be a very broad-minded, a very broad-based
Yes, sir.
country. We are sometimes considered to be conservative, correct?
Yes, sir.
Are you aware what the European Court of Justice in 2021 said about hijab? Please ask your researcher to check up the judgment of the European Court of Justice, July 2021, where the European Court of Justice has said wearing of hijab cannot be claimed as a matter of right.
In fact, a very similar issue arose there when they went wearing the hijab. The schools were not admitting them, right?
So, but if we consider about talking about India, there are many religions which are being followed over here and many diverse cultures which are being followed over here. So we can go with the essence of uniformity, but also by respecting others' religious perspective. We can say that it is the essence of Islam to submit to the will of Allah.
Madam, we respect every religion, but please understand. Sabarimala was considered to be very sacred in terms of the thought process of individuals, of every Hindu.
Yes, sir.
But the Supreme Court said, no, the right of women will supersede. Equality was there. The Supreme Court said there were several protest matters pending in review. So once when, as my learned friend, I think that's why my learned brother Justice Siddharth told about the Indian Anglo-Lawyers judgment. Indian Anglo-Lawyers judgment is the Sabarimala judgment. On one side, you have Sabarimala, where you said there has to be equality for women in Hindu religion. Likewise, the same equality should be there for religion, correct?
Sorry, sir, your voice is breaking.
Shouldn't there be the same equality that the Hindu women enjoy be given to the Muslim women?
So I agree that there should be equality before every perspective in the religious matter, because we see that this is a practice which is being going on since a long time. It is being followed not only in India but in many other countries where Islam is being followed.
Madam, many other countries have started banning hijab, madam. Please understand. Sati was a practice. Sati was a practice where the wife jumps into the fire of the husband.
Right.
That was there for a long time. Can we make it valid? We have abolished it. I think you can take 2 minutes and just wind up. I think subject to what other questions my seniors would have.
Sure, sir.
I have just one last query. Council, are you aware of the Fatima Hussain judgment as well by the Division Bench of the Bombay High Court?
Sorry, sir.
Are you aware of the Fatima Hussain judgment by the Division Bench of the Bombay High Court? Just ask your researcher to get back to us.
Madam, all these judgments are cited in the Karnataka full bench. What my brother is asking, the Kerala judgment, the judgment of Fatima Hussain, everything is cited in the Karnataka full bench. Kindly go through it.
Sure, sir.
That goes against you.
You can even ask your co-counsel to answer those questions if you can't,
Yes.
because you may be running out of time.
Yes, sir. My co-counselor will be answering these questions because I see that I have less time and my researcher is running through those cases. If
You can come back. You can come back.
Agreeable. Thank you, sir. Sir, if the council permits me, can I proceed with the issue 2?
Yes.
Much obliged, your lordships. Sir, in the issue 2, it is the question that whether whether the respective practices of the religion tantamounts to essential religious practice, and whether the right to health outweighs right to religion.
Yes.
In the case of Commissioner versus Commissioner of Police versus Acharya Jagdeshwara and Sri Sirur Mut, it was an essential religious test were determined, and it was stated that this test is to determine whether a practice is essential to a religion or not. And if we take out that practice from that religion, will a fundamental change occur in that religion or not? So we can see that in this case, the court observed that what constitutes the essential part of a religion is primarily to be ascertained with the reference to the doctrine of religion itself. With these cases only, further in Shaira Banu, it was stated that the triple talaq was not an essential religious practice and cannot be given protection under Article 25. And similarly, in Sabarimala case also, it was stated that exclusion of women from the temple is and even in the Haji Ali Dargah case, it was stated that the trust refusing the women to enter into the Dargah is illegal and unconstitutional. So we would say that Quran does not only covers the individual's outer perspective, but it also gives it also governs the internal life of the Islamic people who profess Islam. So basically, they follow first, they have the concept of Quran, and other they follow Sunnah and Hiddaths, which are the teachings of the prophets. So according to this, it was stated that it is the essence of Islam to submission of the will of Allah, and whosoever is not doing that, I would state, if not for a believer or believer men or believer women to have a choice in their affair when Allah and His Messenger decide a matter, and whosoever obeys Allah and His Messenger indeed has strayed or manifested staying. It was stated that this is why the parda or hijab is necessary. The only proper reply would be that Allah and His Messenger have decided so. On behalf of the petitioner, we would say that it is India is a diverse country which has various cultures, and all the cultures should be respected. The personal autonomy, it is a personal autonomy to decide whether what kind of a dress a person wants to wear and what kind of expression they have for their religion and what kind of thing they want to wear in their religion. And it should be contrary to the public health, morality, and public order. We would
Madam,
state,
Madam, I'll just interfere for a minute. See, you are talking about Quran, you're talking about the Islam faith.
yes, sir.
There is a detailed judgment of the Karnataka full bench which goes through elaborately through the Islam faith, through Quran, through several teachings and several opinions. And it has come to a conclusion that wearing of hijab is not an essential religious practice. do you have any demonstrable evidence or material to suggest that we need not look into the full bench judgment of the Karnataka High Court because it is flawed and we have to look at it in a different way?
So,
In 2 minutes, you will have 2 minutes.
so we agree that now the time has changed and things are different, but still there are many conservative Muslim communities who still believe that the lady should not go. Sorry.
Madam, merely because there are few conservative Muslim communities, we cannot help them. If there is a legal mandate, if you are able to establish that it is an essential religious practice, then we can interfere. To satisfy a few conservative groups, let it be Hindu, Muslim, Sikh, anybody, we cannot interfere. I'm sorry.
So I would like to state that due to these conservative Muslim communities, people like students, children, or the girls who are not being allowed to go to their schools just because they don't have, they are not wearing hijabs because the school is not permitting that. Don't you like? I think that that is hampering their right to education, which is much more prior to stating that whether hijab should be there or not.
So you are saying to satisfy that group, we will permit, because a pressure group is exerting some pressure, we will have to permit that pressure group to have their say, madam? Is that what you're trying to say? Is that what you're trying to say, that in a constitutional democracy, merely because a group of conservatists feel otherwise, we should permit it?
Sir, I don't say that mayor a pressure group is saying so, because we have many other religion which are being followed in our country also. That is Hinduism and Jainism. They wear a sacred thread on their body. In Sikhism, they wear turbans on their head and their kirpans, which can be permitted. But why not hijab? Even that is a necessary religious practice in their religion, which is being followed. It is not a practice which is which developed over a time, but it is being followed since many.
Therefore, the question boils down to this: whether hijab is an essential religious practice. If you say yes, then what is the evidence in support of your contention?
In 1 minute, you will have to conclude because you run out of time.
So we only have the say of the Quran that is saying that it is necessary for a lady to cover its body because it is the will of Allah that the lady should be covered, not the face, because it's their choice whether they want to cover it or not, because
All right, probably you can.
Because in the I would like to state the chapter 33 verse 59 in the Holy Quran, which stated that the wives and the daughters and the women who believe in Allah should be covering their lower portions with the jihabs. That is more suitable, and they will be known and not harmed. And even Allah forgiving and merciful.
You said lower portions. The head is a lower portion or what?
Sir, it is earlier also stated that it is not necessary for them to cover their face, but it is necessary for them to cover their body parts. That is their arms. They should be wearing something that is long sleeves.
All right. So your time is up because they already.
Your second.
Yes. Where is the other, your co-counsel?
Yes, sir.
Yes, sir.
Co-counsel can start.
With the consent of your lordship, counsel in front of honorable bench seeks permission to continue the proceeding with issue 3.
Yes.
Yes.
Much obliged, your lordship. Contention 3 states that whether prohibiting the entry with hijab in educational institution violate the fundamental right of the Constitution of Nigeria, the petitioner humbly submits before the Honorable Supreme Court that the government order prohibiting the entry of women wearing hijab into educational institution violates the fundamental right under Article 14, 15, 21, 25, 26, 29 of the Constitution. The petitioner submits the numerous contention to prove the unconstitutionality of the illegal and arbitrary condition imposed by the government. Subpart A states that prohibiting hijab is violative of Article 14 and 15 of the Constitution. It is hereby contended that imposed government order suffers from a gross non-application of mind and a misdirection in law.
Counsel, can we ask you a question straight away?
Yes,
now,
Lord.
what is your locus standi to file this petition? Who are you?
Pardon, sir?
No, no. Who are you to file this? This is a public interest litigation, is it?
Sir, it is a special leave petition.
No, no, that's right. Who are you as a petitioner?
What was it before the High Court, madam?
You were,
In what capacity you had filed the petition?
yes.
Sorry, sir, I didn't get your question.
No, who?
Madam, you filed a writ petition before the High Court, correct?
Yes, your lordship.
Who are you? Are you a educational institution? Are you a group? Who are you?
Sir, here we are government as well as individual as well.
No, see, the moot court proposition says government is one part, where with regard to kirpans and other things, you are defending the government.
Yes,
So
your
far
lordship.
as the other people are concerned, who are they?
Sir, we are Farid Khan and a Islamia Carmia University.
Ah, so that is what
Yes.
Honorable Jayachandran has asked. What is your locus standi?
Understand I? Because the right is given to a particular minority institution. We can say minority institutions. Now, how are you affected? Now, because of this order, it's only the students, but all those who want to wear the hijab, they may be affected. Right?
Because, your lordship, this government order is violating the essential religious right of the individuals.
No, but
From where you got right to challenge?
yes.
What is your understanding? Where
Your
you
lordship,
challenging? How are you affected?
your lordship, as Article 25 states that. Just a minute.
See what 25 says.
Freedom of concise, free profession, practice, and propagation. So, according to this article, the freedom of religion to practice and profess is affected of the individual.
No, no. How are you representing them? You're some of them, some of the students, maybe half a dozen students, they want to wear hijab and come to your college or institution, whatever it is. Now, how are you taking up their cause? How is the government interfering with your establishment or administration of your institution? It's only individuals, if at all they are affected, it's only a few individuals affected. How are you taking up that cause?
Because, your lordship, there is religious right has been affected, and because of that, affecting of religious right also violates educational right, because they cannot carry their essential religious right and come to the educational institutions.
Madam Speaker, I think what the honorable judges are asking really is that how is the university espousing the cause of the students? You may be a minority institution, but the institution itself has to be neutral to all students, whether it's a Muslim or a Hindu or a Sikh. So a student who was wearing a hijab and was not permitted to enter or attend college may have a grievance to, challenge that order, etc. But the university, even if it's minority institution, it has to remain neutral for everyone. How can the institution say that wearing of hijab should be permitted in college?
And to add to that, your co-counsel had said it is not only Muslims who will be admitted in this minority institution, even Hindus will be, even Sikhs will be admitted. So if they are coming in to your college or your university wearing kirpan or some other dress of their own, saying that this is part of a religious practice, would you also agitate that matter? Because it is affecting them.
Because, your lordship, kirpan is a dangerous weapon. That's why we don't defend that kirpan is an essential religious practice that affect the public disorder as well.
Madam, when was the Constitution enacted?
Pardon, lordship?
Which year did the Constitution come into force? Which year did the Constitution of India come into force, madam? 1947, 1950, which year?
1950, your lordship.
Part of it earlier, part of it, okay, 1950.
1950. All right.
Right.
But once when the Constitution was framed, there were constitutional framers from all religions, correct?
Yes, lordship.
But why did Article 25 not say that wearing of hijab is also considered to be included in the profession of the Muslim religion? You are talking about Quran, correct? You are talking about practices. Kindly come to Article 25, Clause 2, Explanation 1 and 2. There is the constitutional framers have consciously excluded hijab because they thought it was not an essential religious practice. Because your constitution provides for that. Your constitution provides something for the Sikhs because they felt that carrying of kirpans, you might call it dangerous, you might call it whatever, is considered to be a practice in professing of their religion. But the constitution does not say the same for Islam and hijab.
But your lordship, it is a customary practice and it is also compulsory mentioned in the Quranic instructions. Where it says that not carrying the hijab, it is a haram in the Quran.
Council, you also answered what Ms. Brar asked as to what is your look standing? Because as a university, how are you taking up this case or the cause of a few students who may not be agitating the matter? Why are you taking up that cause? That answer you're not given in full. And supported with some citations, cases of the Supreme Court.
Your lordship, that in the case of Anma bint Bashir versus Center for Education, it was also held that wearing of hijab is an essential religious practice in Islam, the same being a Quran objection.
No, please ask your researcher to find out that how can an institution talk about or espouse the cause on behalf of a certain section of students within a university. Like I said, there would be, say, 30% Muslims in the university, there would be, say, 10% of Sikhs or, 50% Hindus. So how is the university talking only on behalf of the Muslim students or the hijab bearing students? So please ask your researcher to get back to us on this.
Yes, your lordship, my researcher is working on that. Can I deal with this? Can I answer this issue in the last?
Sure.
Yeah, should answer, but maybe at the end.
Yes, your lordship. Your lordship, subpart B states that government orders are violating of Article 19, 21, and 29 and international conventions. It was categorically held in the judgment of National Legal Service Authority versus University of India that one's personal appearance or choice of dressing is protected zone within the freedom of expression. No restriction can be placed on one's personal appearance or choice of dressing. Whereas Article 21 states that protection of life and personal liberty. It was held in the case of K.S. Swami versus Union of India. What one wears and how one dresses is a matter of individual choice protected in the privacy jurisprudence. Whereas Charu Khurana and others versus Union of India accentuate the gender bias in any form is opposed to constitutional norms. So liberty in matter of belief, faith, and worship must produce a compassionate and human society marked by the equality of status among all citizens. Hereby, the Learned Council submits that the action of the state is in derogation of international convention. Subpart C states that the practice violates the basic structure doctrine of the Constitution. The 42nd Amendment, 1976.
Which international convention is violated? Because of the state government's act of banning hijab. Which international convention is violated? Which international convention provides a right for wearing hijab?
Your lordship, in Universal Declaration of Human Rights 1948, it is mentioned it is mentioned there that right to religion. So as per that, not wearing of hijab violates a right to religion.
Nowhere they have stated wearing of hijab is part of religion. Have they stated so?
But your lordship, it is mentioned in the Quran, and it's as per Quran, it's an essential religious practice.
Madam, please understand. Madam, if there is a conflict between Quran and Constitution, will Quran prevail or Constitution prevail?
Your lordship, in Article 15, Clause C, there can be no against the women and right to wear a clothes.
Madam, please answer my question. If there is a conflict between Quran and the Constitution of India, which will prevail?
Your lordship, Constitution.
That's what we want to answer.
You admitted that.
Council, I have one quick query. Do you identify yourself as an entity that squarely falls within the ambit of Article 12 of the Constitution of India as an educational institution? Do you qualify as
State.
an entity under Article 12?
Pardon, Your Lordship, I cannot get the question.
You as an institution, do you qualify as an entity under Article 12 of the Constitution of India? Yes or no?
Yes, Your Lordship.
And under Schedule 7 of the Constitution of India, these policies fall under which list? The notification, the impugned notification against which you move to the High Court by the state government, that particular category falls under which list under the Schedule 7 of the Constitution of India? Union, state, or concurrent? And do you qualify as an entity under Article 12 of the Constitution of India? These two questions.
Madam, have you got the question what Brother Siddharth has asked? Have you understood?
No, Your Lordship, I didn't clearly understood this question.
Then kindly answer Article 12 and which entry or which list you fall under.
Are you a state within the meaning of Article 12?
Yes, Your Lordship.
Your institution, your university.
But sir, here we are state of Mangalore as well.
No, my brother asked, no, please be. I think my brother Siddharth asked whether your educational institution will be a state. He was clear on that. We are not talking about the state government. What Brother Siddharth asked was whether your institution will be falling under the
Your Lordship, we come under concurrent list.
Did the researcher get the question?
Yes, Your Lordship, we come under concurrent list.
All right, proceed.
Yes, Your Lordship. The 42nd Amendment 1976 introduced the word secular to the preamble when a constitution already had such an animating character ab initio. Whatever be the variance of its meaning, secularism has been a basic feature of our polity held in Keshwananda Bharati. Secularism means a state which does not recognize any religion as a state religion. In the landmark state judgment, Ahmedabad College versus State of Gujarat, the Supreme Court held that secularism neither means anti-God nor pro-God. It ensures that nobody shall be discriminated against based on religion.
Is there a definition of secularism in the Constitution or elsewhere? Let's say Article 366 defines a number of terms. Does it define secularism?
Your Lordship, it is clearly mentioned in the preamble of our Constitution.
What? No, that's right. Secularism is there. But what is the definition? Where does it say in the Constitution? Does it say so? Does the Constitution in any way, in any part of it, define secularism? Where do you get it from?
Sir, we get, it doesn't define any definition, but we get from the preamble of our Constitution.
No, the meaning of it. The meaning of secularism, where do you get that from? The preamble doesn't define secularism, nor is it there in any part of the Constitution, including Article 366, which is the definition article.
Your Lordship, we have referred certain judgment in which it defines that secularism means a state which does not recognize.
Quote one judgment at least.
Yes, Your Lordship. Your Lordship, in Keshwananda Bharati case, it said that secularism is a state which does not recognize any religion as a state religion. And the landmark case as well, Ahmedabad College versus the State of Gujarat, the Supreme Court held that the secularism neither means anti-God nor pro-God. It ensures that nobody shall be discriminated against based on religion. Yes, Your Lordship. In subpart B, prohibiting essential religious practice also violates Article 25 and 26 of the Constitution. Subject to Article 25 and 26 of the Constitution, it was categorically held in the case of Anima bint Bashir versus Central Board of Education, wearing of hijab is an essential religious practice in Islam, the same being a Quranic injunction. Whereas the protection guaranteed under Article 25 and 26 of the Constitution is not confined to the matter of doctrine or belief, but extends to act done in person of religion, and therefore contains a guarantee for rituals, observance, ceremonies, and mode of worship, which are essential or integral part of religion. What constitutes an integral or essential part of religion has to be determined with reference to doctrine, practices, tenets, and historical background. of their given religion. To the above mentioned practices, the imposed government order is structured with a wrong narrative that wearing of hijab is not an essential part of essential religious practice of Islam, and therefore wearing a kirpan is almost totally stripped of its objectivity dangerous characteristics, and hence prohibiting above practice violates fundamental rights. Your Lordship, further the Council seeks permission to continue the proceeding with issue 4.
Yes.
Much obliged, Your Lordship.
Counsel,
Contention 4.
am I audible?
Yes, Your Lordship.
Okay. I want you to distinguish the parameters between essential religious practice and cultural practice. How do you draw the fine line? And do you have any precedents that distinguish both the practices clearly? Because I can cite you 3 precedents of the apex court which says that there is a huge difference between what can be construed as a religious practice and what can be construed as a cultural practice. There are further precedents which state that hijab is essentially a cultural practice and not a religious practice. So get back to me over that particular query, that how do you distinguish between religious practice and cultural practices along with precedents?
Yes, Your Lordship, right now I have to deal with contention 4 or I have to answer this query?
All right. Proceed.
Whether the right to education be denied for want of proper dressing uniform of an individual. The petition humbly submit before the Honorable Court that the act of prohibiting the headscarf in the educational institution violates the fundamental right. The petition humbly submits numerous contention to prove that. Subpart A states that prohibiting headscarf violates essential religious practice guaranteed under Article 25 and 26. Religious practices are a set of rules or principles for the attainment of belief in supreme power. Religious practices are what religion teaches, essential or integral part of religion to be ascertained from the doctrine of that religion itself according to its tenets, historical backgrounds, and change in evolved process. Only integral and essential part of the religion is protected. Therefore, in the landmark case, Anma bin Bashir was the Central Board of Education, that the dress code shall not be enforced against the candidates who, by virtue of Article 25, are protected from wearing such dress as prescribed in the injunction of their faith. The right of women to have the choice of dress based on religious injunction is a fundamental right protected under Article 25, when such prescription of dress is essential part of the religion. Therefore, the court has to examine the nature of the dress code prescribed for women in Islam, and such prescription is an essential part of the religion or not. And if it forms part of essential religious practice, can it be regulated in the light of Article 25? Thus, the analysis of the Quranic injunction and the Hadith will show that it is a first to cover the head and wear the long sleeve dress, except from face apart, and exposing the body otherwise is forbidden, that is haram. Subpart B states that order is violative of right to education and UDHR Article 26. The citizens of this country have a fundamental right to education. Article 21 has been interpreted by this court to include the right to live with human dignity and all that goes along with it. The right to education flows directly from right to life. In other words, the right to education is cantonment to the fundamental right enshrined in Part 3. Therefore, it needs to be understood that the control of Article 26
does Part 3, dealing with fundamental rights, deal with the right of education as well?
Yes, Your Lordship.
Wherein?
Your Lordship, it is mentioned in Article 21, Part A.
21, capital A, that is?
Yes, Your Lordship.
6 to 14 years, compulsory education for children of ages 6 to 14.
Yes, Your Lordship, but
talking about higher education as well, right?
Yes, Your Lordship.
So, but there are decisions of the Supreme Court which has read Part 4, the provisions of Part 4 in along with the Article 21, right to life, right? Which
yes, Your Lordship.
Can you suggest any case law of the Supreme Court which has said that right to education is also a fundamental right, though it is only in Part 4 of the Constitution, which is only the directive principle of state policy. In which case, this is like one case where they have said it is concomitant to a fundamental right, because it'll be right to life as well. Right to life, I mean, it is almost everything under the sun. The Supreme Court has taken into Article 21. So, in which case they cite one case. Now, 21 capital A, which is introduced recently,
Yes, Your Lordship. That's why I have included Article 26 of UDHR as well. Which
Madam, please understand.
Case.
Madam, please understand what the honorable judges asked. Is any judgment of the Supreme Court that says right to education is an integral part of Article 21? Is there any judgment where the Supreme Court has
Yes,
said
Your
so?
Lordship. Yes, Your Lordship.
Which case law?
Your Lordship, in Mohini Jain and Unique Christian versus State of Andhra Pradesh, it states that the right to education is a fundamental right that directly flow from right to life under
All right.
Article 21 of the Constitution.
Then why did you quote 21A? 21A doesn't deal with, these are for children who are.
Your Lordship, I have covered the junior children as well and the seniors as well. And whereas I have covered the DPSPs as well, Article 45 and 41 of the Constitution.
All right, carry on.
Yes, Your Lordship. Therefore, it need to be understood that the control of Article 26 is establishment of a religious institution so as to acclaim the status of religious denomination, whereas Article 25 guarantees the right to practice religion to every individual, and the act of practice is concerned primarily with religious worship. The above practice is violating
Madam,
on the
but I'll
ground
just
of...
interrupt for a minute. You were referring to 21A, correct?
Yes,
And then
Lord.
subsequently, as Honorable Justice Jayachandran said, you've come to Article 21. But insofar as 21A is concerned, you have the RTE Act, the Right to Education Act. Is the Right to Education Act applicable to minority institutions? The granting of quota, is it applicable to minority institutions?
Yes, Your Lordship. Yes, Your Lordship.
Did the Supreme Court in Prabhanti Educational Trust tell otherwise?
Pardon, Lordship.
Did the Supreme Court in the case of Prabhanti Educational Trust tell otherwise? Just ask the research of the follow-up. A judgment of the Supreme Court that dealt with the RTE Act and whether it will be applicable to minority institutions. Prabhanti Educational Trust. Come back to us in Prabhanti.
Yes, Your Lordship.
Ask
The
your
above...
researchers to follow it up.
Yes, Lordship. The above practice is violative on the ground of prohibiting essential religious practice and imparting from education institutions. Additionally, violative of Article 26 of UDHR. Lastly, in front of Honorable Bench, the Council seeks permission to proceed with the prayer.
Yes.
Much obliged, Your Lordship. In the light of the facts stated, issued raised, argument advanced, and authority cited, the Council, on behalf of Upland, humbly prays before the Honorable Supreme Court to kindly adjudge and declare that the petitioner's fundamental right has been violated under Article 14, 15, 19, and 21 on the banning of essential religious practice that violates the right to equality, right to privacy, and freedom of religion. That the petitioner's essential right has been violated under Article 25 and 26 of the Constitution of Nigeria. That the petitioner's prohibiting petitioner's entry with hijab into education institution violates right to education, Article 41 and 45 of the Constitution of Nigeria, and or pass any order.
Madam, I just interfere. You are on an appeal, correct? You are not on a writ petition seeking this relief. You want the appeals to be allowed, or you want the appeals to be dismissed? You want the special leave petition appeals to be allowed or dismissed?
Sir, we want to be allowed.
First, we will have to convert it into a civil appeal, only then we can allow it. All right, we consider, madam. We consider. You want the appeals to be allowed, correct?
Yes, Your Lordship.
All right, thank you.
Pass any other order which the bench deems fit in the best interest of justice, equity, and good conscience. And for this act of kindness, the Council, on behalf of Upland, as in duty bound, shall forever pay. Much obliged, Your Lordship.
All right.
Thank you.
Any questions from any of the panel?
Which for respondent?
Now the respondent side, team 4, can start presenting their arguments. All the speakers are requested to keep an eye on the time limit mentioned in the chat box by the timekeeper. Teams are requested not to exceed the time limit. Team 04 can start now.
You can also announce, because what happens is sometimes we don't notice that you are putting into the chat box that time is up. But probably you can even announce it. You can interrupt and announce that your time is up.
Yes, sir. Actually, we don't do it by unmuting ourselves because sometimes the speakers get disturbed with the voice. That's why we kept it in the chat box.
They should not get disturbed because you're just telling them.
Or you can show a placard.
Yeah, something like that. Because even I saw it in a flash. The time was up and then nobody noticed it. I think the speaker especially.
Okay, sir, noted.
Nitya, you can show it in a placard like this.
Yes. Saying that your time is up.
Yes, sir.
Yes, respondent, if you're ready, respondent.
Yes,
Speaker one.
yes, sir, I'm ready. Am I both audible and visible?
Yes, you can proceed.
We can.
May it please the Honorable Court, Counsel 1 for the respondents in the present case of Islamia Karimia University and others versus State of Tattoon and others. Counsel 1 appears on behalf of the State of Tattoon, Ishan Arora and Mr. Rajendra Jain. Counsel seeks permission to address this bench collectively as your lordships.
Yes.
Indeed, your lordship. Would your lordship require counsel to state the facts of the case?
In brief.
The Federal Republic of Machin came into existence in 1947. The Federal Republic of Machin consists of 4 states, which are Tattoon, Kondo, Mangalore, and Napo, where 50% of the population of the state of Tattoon are Hindus and 50% of the population in the state of Mangalore are Muslims. The state government of Tattoon issued a government order dated on February 15th banning headscarf or hijab in schools and higher education institutions. Islamia Karimia University filed a writ petition before the High Court of Tattoon challenging the impositions of arbitrary and illegal conditions on minority educational institutions and interfering with the administration of minority educational institutes, which violates their fundamental rights.
Yes.
Another writ petition was filed by Ms. Fardeen Khan challenging the government order as violator of their fundamental right to the religion and education. The High Court of Tattoon dismissed both the writ petitions. Islamia Karimia University and Ms. Fardeen Khan filed a special leave petition before the Supreme Court. Coming to the state of Mangalore, it also issued a government order on date of February 23 banning all the religious turbans and kippans in school and educational institutes. And on February 25th, another government order declared Paryushan Perv among school children as illegal. Ishan Arora filed a writ petition before the High Court challenging the denial of education and violation of fundamental rights. Another petition was filed by Mr. Rajendra Jain on the ground that fasting during Paryushan Perv is an essential religious practice for the Jain community. The High Court of Mangalore allowed both the petitions and held that wearing turban and kirpan and participating in Paryushan Perv is also an essential religious practice. The state of Mangalore also filed special petition before the Supreme Court. As the court is well aware of the facts, counsel proceed with the issues.
Yes.
There are mainly 5 issues raised in the case. Your Lordship, the first 2 issues will be dealt by Counsel 1 and the other 3 issues will be dealt by Counsel 2. Your Lordship, counsel seeks permission to move on with the first issue.
Yes.
The first issue is whether the respective religious practices of the community stand amount to essential religious practices. The state of Tattoon humbly submits that hijab is not an essential practice of Islam, and counsel on the part of the Ishan Arora and Mr. Rajendra Jain humbly submits that wearing kirpan and turban and celebrating Paryushan Perv is an essential practice of the Sikh and Jain communities. The essential practice means those practices that are fundamental to follow a religious belief. And one of the tests which have been applied to see is by taking away the part or practice which could result in the fundamental change in the character of the religion or belief.
Also, where do you find that these two are part of essential part of religion?
Counsel would be dealing in detail in the further points, Your Lordship, while discussing how hijab is not an essential practice.
Before you move on to that, I think already I've indicated to your other speakers on the other side with regard to what is available in Article 25. Except for kirpan, which is recognized as a part of the Sikh religion, no Hindu, Christian, Muslim, Jain practices have been recognized under Article 25. So if your argument is that hijab is not an essential religious practice,
I think Lordship is on mute.
Same logic should apply, correct? For all.
Your Lordship, would you please repeat the question, please?
See, Article 25 only talks about kirpan being a part of the Sikh religion. Any other practice is not recognized under Article 25.
Indeed, Your Lordship.
So if you are trying to argue that hijab is not a part, same logic will apply to anything else.
You should show.
Your Lordship.
Yes, as a corollary to this, you should also show wearing of turban and also fasting during certain days will be part of the religious practices.
Indeed, Your Lordship. In the case of Shirur Mat case, it was mentioned that the proposition that all essential religious practices were protected by Article 25, Your Lordship. As hijab being not an essential practice, and turban and kirpan and celebrating fast during Paryushan Perv are essential religious practices, those will be protected under Article 20.
Where do you find that? But these two are essential part of the Hindu religion.
Now council will be dealing with that part of the issue, Your Lordship. This issue is further being argued under three aspects. The first point is that wearing hijab does not constitute an essential practice of the religion. Quran does not mandate hijab, Your Lordship. In Abdullah Yusuf Ali's book, the Prophet quoted in Surah 2 verse 256 in Holy Quran that let there be no compulsion in the religion. And also in the Surah 33 verse 59 at the footnote 3765 in his book states that jilbab, plural jalabib, an outer garment, a long gown covering the whole body, or a cloak covering the neck as bosom. And also in the footnote 3760 to the verse 53, he states that in the wording, note that for Muslim women, generally no screen or hijab is mentioned, but only a veil to cover the bosom and modesty in the dress. Thus, there is sufficient intrinsic material within the scripture itself to support the view that wearing the hijab has only been recommendatory. And also in the case of Re Fatima Hussain case, Bombay High Court discussed regarding the Muslim girl students' right to wear hijab. In this case, it was held that in the exclusive girls section cannot be said to be in any manner acting inconsistent with the aforesaid verse of 31 or violating any injunction provided in Holy Quran. It is not obligatory overt act enjoined by the Muslim religion that a girl studying in the girls section must wear a head covering, Your Lordship. So there is absolutely no material placed on the record to prima facie show that wearing of hijab is a part of essential religious practice in the Islam. This apart, it can hardly be argued that hijab being a matter of attire can be justifiably treated as a fundamental to the Islamic faith. And coming to the second part of the issue, that wearing a kirpan and turban constitutes an essential practice of the Sikh. In Sri Guru Granth Sahib, which is the Sikh scripture containing the composition of the Sikh Gurus, the turban became a symbol of Sikh identity under Guru Gobind Singh, who is the 10th and last Sikh Guru. Guru Gobind Singh also introduced the 5 Ks, which are kes, long uncut hair, kara, bracelet, kanga, wooden comb, kirpan, small sword, and kachera, which is shorts. Council will be arguing this part of the issue under 2 grounds. Firstly, turban being an essential practice, and secondly, kirpan being an essential practice. Coming to the first round,
we'll go to that. We'll go to that. Doesn't your Muslim friends fast during Ramzan?
Indeed, they fast during Ramzan, Your Lordship.
Isn't that a religious, essential religious practice?
It is an essential religious practice, Your Lordship.
Is it there in Quran?
It was mentioned in Quran, Your Lordship.
Where in Quran? Which class? Which verse has it been mentioned?
Council would come back to the number with the number of the verse in the later part, Your Lordship.
So,
the researcher will come back.
Jilbab also finds place in Quran, correct?
Your Lordship.
It's not as if jilbab has never been mentioned. See, you are talking about Guru Gobind Singh, and ultimately, you have to accept that Article 25 also deals with the Sikh religion. But insofar as Islam or Jain or even Hinduism, insofar as your saffron scarves or what you wear in your hand, all that is not considered to be an essential religious practice. But we are permitted. As students, you are permitted to wear something in your hand and come to school. You are permitted to have your vibhuti or kumkum in your forehead. So you cannot apply double standards for Hindus, Jains, and then discriminate Muslims. Either say nothing will be done if you want uniformity, or permit everybody. What's wrong?
Your Lordship, Council is stating that there are 5 principles for the Muslim. Those are belief, prayer, fasting, giving charity, and pilgrimage to the Hajj. And coming to the verse where it was regarding the fasting is in the Quran chapter 2, 183. O you who believe fasting is prescribed for you as it was prescribed for those before you, that you may develop God consciousness. So regarding fasting, it was mentioned in the Quran. And when coming to the word jalabib, it was told that it is an outer garment, a long gown covering the whole body, or a cloak covering the neck as bosom. It didn't mention it should cover the hair, Your Lordship. It told it should be covered the neck area and the chest area in the verse 59 at the footnote 3760.
Are you trying to say they can wear this burqa and come to the college or school?
Your Lordship, the Council is stating that hijab was not mentioned, Your Lordship.
No, you are now saying probably what is mentioned there is full dress, full covering. So instead of hijab, they can come with this burqa.
In the same verse, it was mentioned like this, Your Lordship. An outer garment, a long gown covering the whole body, or or a cloak covering the neck as bosom, your lordship.
So,
So it was telling that
is that
it was mainly the Quran is recommending regarding the covering of the body in a modest way of dress, your lordship.
heavens can counsel? Are you now saying that hijab is prohibited, but this burqa, the entire covering of, from top to toe, that is
Yes.
allowed, that should be allowed, is it?
Your lordship, council is not contending like that, your lordship. Council is contending that Quran is talking about the modesty of the dress. That uniform also covers the body, your lordship. That is what council is contending, but not regarding the hair where they are talking about the word hijab, your lordship.
All right, proceed.
Indeed, your lordship. Coming to the turban being an essential practice, it was the following quotation from the Guru Granth Sahib clearly shows that
How do you separate your head with other part of the body?
Your lordship, council is not contending that head should be separated. It was mentioned in the Quran that dress should be in a modest way, covering the neck and the upper body
But
area.
hijab is also a modest way.
Your lordship, the word hijab was not being introduced in Quran. It didn't mention that here the council is mainly contending hijab is no because of the social separateness, your lordship, which would give it.
But even if it is not mentioned, how does it affect? It is a modest way of putting cloth on head. What is wrong with that?
But in Quran, it was not mentioned hair being an adornment, your lordship. That is the reason council is contending that it is not mandatory. It is not
Council,
mandatory.
why are you so hell bent on saying hijab should not be there? Your dear friend, your dear co-speaker is wearing hijab, and we appreciate that.
Council,
So you should appreciate that. You should appreciate that.
Indeed, council appreciates that, your lordship. Council is talking regarding the ban of the hijab. It is being not unconstitutional because hijab is not an essential religious practice, your lordship. That is what council is contending. Council is not stating that.
Doesn't your state government know this for the last 70 years? Now suddenly, is it probably that some other purpose are coming, votes are coming, you are trying to get this?
Council.
I hope the governmental actions are not covered by any mandate that they are batting for, playing to the gallery. As judges, we can only say this much. We can't tell beyond that. For 70 years, you have allowed, madam. Please understand, your friend is wearing a hijab. I am wearing something in my hand. All of that is considered to be a part of our religion. What's wrong? In what way is a prejudice caused? By wearing hijab, what right is violated?
Your lordship,
of a fellow student or the education institution?
Your lordship, the ban is regarding the constitutional morality, secularism of the country, as hijab is not an essential religious practice. The council is contending that.
Why should it be banned? All right, those who want to wear hijab, let them wear and come to the school or college. Why should it be banned?
It will show the because for the reason of the uniformity, the state has been banning hijab for the only school and higher education institution, your lordship, not in the
school or college can say, all right, this is a uniform color combination, whatever. But then this is an additional wearing. Suppose they just wear, some of them have hijab and come to the college.
Then it would result in social separateness, your lordship.
Madam, I had a very good friend who was a very bright student in my class. She was wearing hijab for the 4 or 5 years I studied with her. I didn't feel any discrimination. I didn't feel any ostracization.
Only after this order is passed, there has been a lot of problems. Till then, nothing happened as it was mentioned.
Now, suppose a person, a Hindu comes with a Bhagwa shirt or kurta, will he be banned?
It depends upon the school's regulations and the rules that ought to be followed, your lordship. If the uniform is mandatory in that particular school, then the Hindus are not ought to wear such dress to the school, your lordship.
They can't wear this saffron towels or something, what they were wearing, shawls.
It depends upon the essential religious practice of that religion, your lordship.
No, but why there is no ban for all the other colored clothes?
Your Lordship, if that is being practiced and social separateness has occurred, then that would also be banned, Your Lordship. If it is not an essential religious
Madam,
practice.
with regard to as exactly Honorable Justice Daga sir has asked, we see saffron scarves, other things. Is that prescribed in Bhagavad Gita?
Council is not aware of that, Your Lordship. Council doesn't think that it was.
But what has your High Court done? What has your High Court done? Your High Court has even dealt with Jains. Has certain practices being approved in the Constitution? No. See, you cannot be selective. Our only concern is paint everybody with the same brush. Either say no to everybody or say yes to everybody.
Your Lordship, Council is differing because hijab is not an essential practice, but whereas turban and kirpan are essential practice of the religion. That is why Council is differing at one point of time.
No, we are not on turban and all that. We are on a saffron dress, saffron color kurta shirt. Why should it not be banned then?
Council is stating the same thing, Your Lordship, that if it became an issue regarding that, then if it is not an essential practice, then it would have been banned for the uniformity in the schools, Your Lordship.
Hijab is being created as a class by itself. Is it a reasonable classification under Article 14?
Your Lordship, Council could you please repeat the question, Your Lordship?
If all the questions you are asking this co-counsel to deal with, what are you dealing with it? You should also answer and then.
Council, please ask what Honorable Justice Daga sir has asked. Is there a reasonable classification under Article 14 to classify hijab on one side and other dresses or clothing on the other side? Is there any rational nexus?
There is reasonable classification under Article 14, which talks about the equals to be treated in an equal way, Your Lordship. So the council is only contending that as one particular aspect is not an essential religious practice, that should not be followed. But if it is an essential religious practice, that should be followed. So that is how equal should be treated in an equal way. That is how reasonable classification comes into the place, Your Lordship.
Classification is one thing. The reasonable access to the object sought to be achieved is another thing, right? What is the object that you seek to? That should also be reasonable.
The object here is that the main object here is that it is regarding the uniformity, Your Lordship.
Council, see, as Honorable Justice Jayachandran has said, that classification is one part, correct? The rational nexus is the most important part. What is the rational nexus? What is the objective sought to be achieved? You are saying it's to put everybody on equal pedestal. In what manner, by wearing a hijab, a person becomes an unequal? He perhaps stands out because it's his practice. See, you're saying that Sikhs can wear turban and come. So a young boy wearing turban will be considered to be a Sikh. Will students push him out and say, no, we are not going to talk to you? They are going to talk to him. Equality is going to be maintained. Likewise, same thing applies for hijab. Why is that there is something so specific you want to throw that out?
It is not regarding the specific aspect, Your Lordship. It is regarding the secularism and uniformity which is to be maintained, Your Lordship.
All right. I think you've exceeded your time. Any more questions if my seniors have? Otherwise, I think you can ask your co-speaker to be.
Yes.
If the Lordships are satisfied with me, with my arguments, with the council's arguments, council too would be proceeding with the other issues.
If we are not satisfied, we'll pull you back again.
So we can't declare that now.
Indeed, Your Lordship. Now, council too will be proceeding with the other issues.
Yes, second council.
Second council, where is the second council?
She's on mute.
You're not audible. You're not audible.
Oh, yes.
Council, you can speak now. Council 2, you can speak now. No, you're not audible. You're not audible.
You need to maybe change your output settings to your mic from your laptop.
Can the council too talk from my
Yes,
this account, Your Lordship?
we can. No problem.
Give us a minute, Your Lordship.
Yes.
Yes, she can start, ma'am.
Madam, if you're sitting next to each other, you can just pass on your headset, no problem.
I was audible and visible, Your Lordship.
Yes, yes.
May it please the Honorable Court, this is Counsel 2 on behalf of the respondents. This counsel will be dealing with the 4th, 5th, and 6th issue. The 4th issue is whether minority educational institutes have an absolute fundamental right in their favor. Islamia Karimia University filed a special petition challenging the order passed by the High Court of Tatooine on the ground that minority educational institutes have an absolute fundamental right which cannot be restricted by the government in any manner.
Slow. We are not catching a train. Slow. Be
Much
calm.
obliged, Lord.
We have all the time. Slow. Yes, proceed.
Your Lordship, the Constitution through Article 30 empowers the minority communities to establish and administer educational institutes of their choice. While examining the scope of Article 30 in the context of Article 30, Clause 1, no right can be absolute and no community can claim its interest above national interest. In the famous Kerala Education Bill, the Supreme Court has observed that the right conferred on the religious and linguistic minorities to administer educational institutes of their choice is not an absolute right. In TMA Pi Foundation case, the court held that Article 30, Clause 1 was neither absolute.
What was the bench strength of TMA Pi?
Counsel begs your pardon, Your Lordship.
What was the constitutional bench strength? How many judges sat and delivered the TMA Pi judgment? 7, 9, 11?
It was 11 judge bench, Your Lordship.
All right.
Your Lordship, it is very clear from the above views that of the Supreme Court that the right provided to religious minorities under Article 30, Clause 1 of the Constitution is not absolute. This right is subject to the basic and overriding principles of our Constitution, such as equality and secularism. Hence, if such regulatory measures are introduced in schools related to all religions for quality checks of religious instructions to be given to the children, then such measures are constitutionally valid. In such a way, individual rights of children and collective rights of the minority community can be harmoniously construed, which could be beneficial for the country as a whole also, Your Lordship. Therefore, the right conferred on the religious and linguistic minorities to administer educational institutes of their choice is not an absolute right.
Can you hear? Can you one second? Pause for a second. In fact, you've already been told that you're not going to catch a train. Maybe you're going to catch a plane. So you just slow it down a little bit. Now, in Article 19, see now 14, 19, 21, all of them form a common code. That's what the concept said, right? Now, Article 19, which is very important, the freedoms, the basic freedoms have been mentioned. Each freedom, like for example, Article 19(1)(a), freedom of speech and expression. Now, 19(2), there are grounds on which reasonable restriction can be imposed by the state, which is defined. State is defined under Article 12. Now, in these articles, which grant certain rights to minority institutions to establish and to administer, establish and administer.
I lost the connection.
No, I think that is the problem. Just we'll wait for a minute. Riddhi, if you can just check up with the Honorable Justice Jayachandran if there is a.
Yes, I am doing the same. Your Lordship has joined.
Can you hear? Sorry.
Yes, Your Lordship.
Sorry, ma, it just got disconnected. Let her carry on. Yeah.
The fifth issue is whether right to health outweighs right to religion. Right to health does not completely outweigh right to religion. Council would like to support this statement on 4 points. Point number 1, no right under Article 21 can be to the negation of rights of citizens under Article 25. Point number 2, right to religion not only includes Article 25 but also includes Article 21. Point number 3, fasting during Paryushan Parv does not affect the health of the students. And point number 4, Kirpan is not a weapon. Your Lordship, fasting during Paryushan Parv does not affect...
How do you, okay, can I ask you a question? How do you say Kirpan is not a weapon?
Your Lordship...
Now, in fact, in places like Australia, even pepper spray is not allowed. You know, even a small knife, a nail cutter knife, you can't carry because that's considered to be a weapon and prohibited. From where do you get this, that Kirpan is not a weapon?
Your Lordship, Kirpan is sheathed and covered, and it is a symbol of non-violence. So people don't generally use it as a weapon, and it is wrong.
No,
Generally,
even in airport, you are not allowed to carry with you.
Yes. How will you? Can you carry a Kirpan in a flight?
Yes, Your Lordship, in all domestic flights, Kirpans are allowed.
Huh.
No, you can't travel with Kirpan. You have to deposit with the
Madam.
And after getting down, you get back your Kirpan.
And because you were saying, because it is in a sheath, that you know it can't be harmful. So any moment it can be pulled out and then poked. So anyway,
Your Lordship, it is
it has been allowed by, if you say it is recognized by the Constitution, it is an essential part of religion, therefore it should be, that's a different argument altogether. But if you say it is not harmful, usually people don't use it. What if they get annoyed or angry and suddenly they start poking somebody?
Your Lordship, that is not the purpose of having a Kirpan. Kirpan is a mode of...
No, you also have in Article 19 to assemble peaceably without arms. Why do they say that? Because you can assemble in groups. But if you're carrying weapons, suddenly that can become violent. Some emotional issue, and then argument starts, and then it can become violent. So the possibility that it can be used as a weapon, that is what we are asking you. You're saying because it is kept in a sheath, usually they don't use it, therefore it is harmless. I mean, that's not an argument that can be accepted. All right, carry on.
Much obliged, Your Lordship. A fasting during Paryushan Parv does not affect the health of the students. A rational balance needs to be struck between the protection of health versus the mental health, that is the religious freedom of the individual.
Madam, I will just stop you for a minute. Did you have breakfast in the morning?
I'm fasting now, Your Lordship.
Oh, you're fasting.
Yes,
Can
sir.
a young girl or a boy about 7-8 years come to school at 7 o'clock in the morning, stay till evening 4 o'clock without having food in the morning?
Your Lordship, in Paryushan Parv, having boiled water between sunrise and sunset is allowed.
Between sunrise and
sunset?
What all can you have?
Boiled water.
Just boiled water. Can a 7-year-old? You will have to see it in the perspective of the particular person. You're a college student, correct? So naturally, your body, your metabolism is much better than a 7 or 8-year-old. So you can fast. I can fast. But can a 7-year-old or 8-year-old fast? Merely because the religion imposes something on them?
Your Lordship, also the fasting for 7 or 8-year-old is not mandatory, Your Lordship. Here, all fasting is banned in all schools and higher educational institutions, which means in colleges also, students are not supposed to fast, cannot fast because of this ban.
But
no, they are saying it for health reasons. They are saying for health reasons, you should not be hungry. Therefore, you have the food.
Your Lordship, here, even if students are healthy enough to fast, they are not allowed to fast due to the ban. Even fasting during Paryushan Parv is permitted if people are not keeping good health, they are exempted to fast, Your Lordship. But here, even people, if they are keeping good health or healthy enough, are forced not to fast or forced not to practice their essential religious practice.
All right. Your point is that there is a religious faith. Article 25 is very important. Therefore, I should be permitted to fast. What happens if a gentleman or a young boy or a girl develops dehydration or develops, some other issues, starts fainting or develops a health problem and his life is threatened? Merely because of Article 25, 21 should be compromised?
Your Lordship, in that case, if a person is dehydrated or faints, they need not continue their fast. They can break their fast, Your Lordship.
So, madam, you are saying 25 is supreme, 21 should be subservient to that. So, 21 will be an exception to 25, not the other way around, correct?
Lordship, Your Lordship, the Council is contending that no right under Article 21 can be to the negation of rights of the citizens under Article 25. There should be balancing, and total extinguishing of a right is not
question
balanced.
is 25 and 21 conflicting, which will prevail?
Article 21 and 25 should be harmoniously construed, Your Lordship.
21 and 25 conflicting. Harmonious construction is well aware. But supremacy of competing rights is also an aspect that has to be considered by the courts. Which right is supreme? 21, 25?
Article 21 is supreme, Your Lordship.
Proceed.
Point number 4, Kirpan is not a weapon. The Supreme Court of Canada in Multani case upheld the right of a Sikh student to wear a kirpan while attending the class. And in Dilawar, similarly in Dilawar Singh versus State of Haryana, it has been held that kirpan should be considered as a religious symbol relating to the Sikh religion, and that there should be no restriction on wearing kirpan by Sikhs while appearing in the court. Similarly, in DSGMC and others, versus Union of India and others, the petitioners or applicants were agreed by the conditions, right nature of restrictions of entry of the candidates with the objects such as rings, bracelets, and metallic objects, which would preclude them from wearing the kara, which is the metallic bracelet that they wear, and kirpan, the ceremonial dagger that they use, which are mandatory for all those who profess the Sikh religion. And the court therefore held that the CBSE should forthwith indicate a special procedure in addition to the existing procedure, particularly stating that that such Sikh candidates who wish to wear the objects concerned on their person should report 1 hour earlier than the reporting time. Your Lordship,
is there any other country apart from India? Let's forget the Indian scenario because we will have to look at other practices also. Any other country like US, UK, European Union permits the carrying of kirpan?
Yes, Your Lordship. There is no blanket ban on kirpan in any other country, Your Lordship. Internationally, every country allows.
What about the 2017 judgment of the Italian court that laid down a ban? What about the 2017 judgment? What about the 2019 UK Act? Is it helpful for carrying kirpan? Does the UK Act provide or permit kirpans to be carried?
Council is not aware of the fact, Your Lordship. Researcher will
check up and come back.
Much
There's the Italian court judgment of 2017 that bans carrying of kirpan. 2019 Act might actually be in your favor, the UK Act. Yes, proceed, madam. Proceed.
Much obliged, Your Lordship. It is besides emphasis that no law prohibits the wearing of kirpan, and on the other hand, wearing them in other public places and even under special conditions such as in aircrafts, during flights, in courts, and such other places are permitted. Your Lordship, the Constitution explicitly and in the plainest terms secures to the petitioner in the explanation of Article 25 Clause 1 the right to wear kirpan and carry kirpan as being included in the profession of Sikh religion. So hence the ban on kirpans and fasting during Paryushan Parv cannot be justified under the notion.
Madam, let's not get Paryushan Parv is for whom? Sikhs or Jains?
Jains, Your Lordship.
Is that recognized under Article 25?
No, Your Lordship.
So don't take Sikhs. So we will exclude Sikhs for a minute because Sikhs, your kirpan is a part of Article 25. I think you can take 2 more minutes. Answer us as to how a Jain should be treated positively, Paryushan Parv, and as to how a Muslim should be treated on the other side because it is not an essential religious practice. Jain versus Muslim, just convince us as to why we should accept for Jains, not accept for Muslims.
Your Lordship, Paryushan Parv, celebrating Paryushan Parv is an essential religious practice.
From where do you get it?
Pardon,
From where do you get that, madam?
Your Lordship, in the celebrations of Paryushan Parv is a practice that is extended.
Does not recognize that.
Where do you
like
get it
Bhagavad
from?
Gita or like Quran, is there anything else where the Jains have to so clearly say?
Your Lordship, it is a customary practice from Bhattaraka
Your
era.
friend just argued against you. He said, Jilbab, even though Jilbab is recognized under Quran, he says, no, it is not so essential. So something that is there in Quran is thought to be classified as non-essential, but you are saying customary practice will make it essential. It is a radical comparison.
Your Lordship, in this case, it is a customary practice which has been followed from time immemorial, and only fasting during Paryushan Parv is banned by state of Mangalore only as a retaliation for the ban of hijab, Your Lordship, and not otherwise. That is why.
Pardon?
Your Lordship, ban on fasting during Paryushan Parv is a retaliation for the by state of Mangalore, because state of Tatooine banned hijabs.
Madam, let us not make it political. Then the question would be, merely because there was some other consideration that you wanted to have the hijab ban for electoral reasons. If I'm not wrong, your aviation ministry has relaxed only in March 22, about just a month back, for reasons best known to you, for carrying kirpan. So let us not make it political. Don't make political arguments. Your point is, we are very clear on asking the question, how is hijab on a lower level compared to Paryushan Parv, once when both are not recognized by the constitution? Is there any judgment or is there any text which is so unquestionable where we will have to agree with that?
Your Lordship, in Ramnath case, it is held that usage outweighs religious texts.
Which case?
Ramnath case.
Citation?
Full citation.
The researcher will get back to you on that, Your Lordship.
You should always which court? Supreme Court? High Court?
Supreme Court, Your Lordship.
Get back to the citation.
Yes,
Now, can you cite the para where in your pleadings where the particular case law has been mentioned?
The researcher will get back to you on that, Your Lordship.
Madam, researcher is not arguing.
Yes. You have your memo with you.
It is there in your memo.
You have your memo, right? With you?
Yes, Your Lordship. It is not mentioned in the memo.
It is not there in your memo.
Yes, quickly, madam. You have 2 minutes.
The next issue is whether right to education be denied for want of proper dressing or uniform of an individual. Council will be arguing this issue. Your Lordship, right to education shouldn't be denied for wearing turbans for 3 reasons. Reason number 1, turban is an essential religious practice in Sikhism. Reason number 2, education is a fundamental right guaranteed under Article 21A. Universal Declaration of Human Rights provides right to education, and that no
Madam,
student.
we know about that. Our only question is, even kirpan or turban, we will step aside for a minute. We are concerned with Paryushan Parv versus hijab. Convince us on that.
Your Lordship,
you are permitting a dangerous knife to be carried on or carried with a person because it is a part of his religion. A mere 25 gram or a 30 gram cloth that everyone wear, including yourself, is thought to be not permitted. Your clients are against you, but you are so generous, you are appearing for those kind of clients.
Your Lordship, kirpan is an essential religious practice, and it is also provided under Constitution in Article 25 explanation 1, Your Lordship. But in the case of hijab, there is no constitutional protection for hijab, and hijab.
You already said that. Forget kirpan. We are on Paryushan Parv versus your hijab.
Your Lordship, while coming to Paryushan Parv, you do not know explicitly if a person is practicing or in fast during Paryushan Parv. But if a person is wearing hijab, you see them and you know them that they are a Muslim. So this creates a sense of social separateness and is against Article 14 and 15, which provides equality and non-discrimination, Your Lordship.
You know what? I will put it. By mistake, I asked, did you have breakfast, without realizing that you are fasting? Okay. If you are my schoolmate or college mate, I will be cautious. I will not even unnecessarily force feed you. So we know, we respect your sentiments. Wearing a hijab has never been something negative. We have respected the sentiments. Why suddenly this discrimination, all these arguments come?
Your Lordship, if hijab is allowed, then school uniform ceases to be uniform, Your Lordship. There shall be 2 categories of students. That is those who wear hijab and those who go to schools and colleges without hijab.
So I will tell you one thing. So are you all right with students coming to school with hijab till the classroom and before they enter the classroom, they will have to remove it in the restroom and come. Is that all right?
Yes, Your Lordship.
All right.
Council seeks permission to proceed with this issue.
Yes.
Reason number 3, wearing turban is not against Article 15 nor against the concept of uniformity in educational institutes. Ban on turban itself is in violation of Article 15. It is a blow to the universal right to education without discrimination, Your Lordship. Government banning only turbans while other religious symbols like hijab, pendants, bangles, and bindis or tilak being allowed in school is also a violation of Article 15 of the Constitution, Your Lordship. There should not be a blanket ban on turban or in the educational institutes and schools. At least they should be allowed in the same color as that of the uniform, Your Lordship. If Your Lordships are satisfied with the arguments, Council seeks permission to proceed with the prayer.
Yes.
Much
Yes.
obliged, Your Lordship. Prayer. Wherefore, in the light of the issues
No,
raised,
all right. Issues raised, arguments advanced. You want appeals to be dismissed, allowed.
allowed, Your Lordship.
Appeals to be allowed. Which
Your
appeals?
Lordship, Rajendra Jain and Ishan Arora, we are
Those appeals to
representing.
be allowed, other appeals to be dismissed.
No, Your Lordship, we are appearing on behalf of Rajendra Jain, Ishan Arora, and State of Tattoo.
No, madam, whichever appeal you are the appellant, you want it to be allowed, other appeals to be dismissed.
Yeah, Your Lordship, Rajendra Jain and Ishan Arora's appeal should be allowed, Your Lordship.
All right. The other appeals preferred by the other side.
Your Lordship, the state of Mangalore has banned Paryushan Parv and Kirpan. So the ban should be lifted, and turbans, the court should held that turbans and kirpans and participating in Paryushan Parv are essential religious practices.
You want costs? You want costs to be paid by the other side to you?
The council is not praying for the cost, Your Lordship.
Very graceful, very graceful.
What's your prayer?
My prayer is A, the minority educational institutes do not have an absolute fundamental right under Article 30. B, turbans, kirpans, and participating in Paryushan Parv are essential religious practices, whereas hijab is not an essential religious practice. C, the government order by state of Mangalore violates the fundamental rights of Sikhs and Jains, whereas the government order by state of Tattooing is not violative of the fundamental right of Muslims. And D, right to health does not outweigh right to religion. And E, education should not be denied for wearing religious outfits that are essential and integral to the religion. The court may make any other such order as it may deem fit in the interest of justice, equity, and good conscience. And for this act of kindness, the respondent shall, as duty bound, ever humbly pray.
Thank you.
Okay.
Thank you, Lord.
We will ask you to be sending biryani on your Ramadan day to us.
Even if the judgment goes against you.
Yes, rebuttal.
Now the petitioner team 02 can go for the rebuttal round and the respondent team 04 for this rebuttal round.
Yes.
Both the teams are having 2 minutes each. You are requested to gather all your arguments or questions and ask in only one go. You may start.
Give them 2 minutes more because their time is consumed by our questions.
Okay, sir.
4 minutes.
Okay,
Yes.
sir. Then 4 minutes each team.
Yes.
Yes, speaker.
Your
Madam,
Lordships,
no, just be specific to what they have argued. So I think already my brother has asked you 2 queries. One is the Bombay judgment, other is the Indian Young Lawyers judgment paragraph. Answer those 2 and be specific to what the other side has argued. Try to demolish that.
Your Lordship, we would like to rebut that they are saying kirpan is not a dangerous weapon, but we would like to state that it is a dangerous weapon, and whereas if we talk about hijab, it is not creating any kind of public disorder or it is not creating any kind of ruckus in the society, because we can see that kirpan is a dangerous weapon and it can be used if a person is having like a moral break, an emotional breakdown or any of those matters. And we would also like to state that they are saying that for uniformity, they can for uniformity, we can also allow hijab in the same color, which is of the school uniforms. That would be considered as uniformity, because we as Indians have respect for every religion, and we would be discriminating if a person is wearing a hijab or something. So we would like to counter on that point.
Yes.
About
Yes,
2 judgments. The Indian Young Lawyers judgment, have you seen which paragraph helps you? And the Bombay High Court Division Bench judgment you have seen, where hijab has been, the ban has been upheld. I think my brother Siddharth asked, correct?
Yes, Your Lordship.
I specifically asked the researcher to get back to us over those two specific queries.
All right, madam, we can proceed. Anything else, you can proceed. I think we would have appreciated come and answer that.
Sorry, sir. It was not.
Unfortunately, our memory is quite reasonably decent. We don't forget what we ask. That is the reason we are asking this. But all right, I think you're not aware of it. You can proceed. Any other points you can make?
So, according to us, para 12 is the point of page 25, which is supporting.
Yes, you proceed in your own way.
All right. Any other points you make, madam? Any other points you make?
No other points, sir, we would like to make. We would just consider these 2 points as our rebuttal. Much obliged, Your Lordship.
Sir, rebuttal specific to this, madam. Sir, rebuttal should be specific to this. Yes.
Am I audible, Your Lordship?
Yes. Yes. Yes.
As the counsel for the petitioner side has put forward that Kirpan being a weapon, counsel would state that according to the code of Sikh conduct with Sikh Rehat Maryada, which is being followed for the Sikhism, it was mentioned in the chapter 13, article 14, clause D that the person to be baptized should not be of a very young age. He or she should have attained a plausible degree of discretion. So, it being an sheathered and secure cover, which will be there upon the kirpan, and the person being having the knowledge of what it is, which is of an article faith and which is for the semblance of non-violence, it should not be considered as a weapon, Your Lordship. And coming to the question which has put forth by the Lordships regarding the UK bill, according to the new offensive weapons bill, which is aimed at tackling of rising knife crime in UK, completed its journey through Parliament, which is an act of law right now. It was mentioning that it is not stopping Sikhs to carry kirpan.
The 2019 Act, correct?
Yes,
2019 Act. Yes, it does permit.
It does permit, Your Lordship.
And what about the suggestion they made with regard to the same color headscarf? Are you all right with that? If the uniform is blue, we will make that also blue.
Your Lordship, if it is an essential religious, if that part comes under essential religious practice, then government would allow if it is in the same color of the uniform. If it is not an essential religious practice, then government would not allow that, Your Lordship. That is what the contention of the council.
You are trying to be considerately firm on your stand. All right, thank you.
Indeed, Your Lordship.
Here we come to an end of this competition. The side of the petitioner and the respondent have presented their arguments in the court very professionally. As a court master, I felt that it was a really healthy learning experience for both the teams. If your lordship and ladyship, you don't have any questions to ask the teams, I would like to say that if you could please give feedback to the teams, how they have performed, how they have presented their arguments and all.
I think we have to ask my senior, this is Jayachandran, Justice Daga and Pradeep sir.
We should speak through our marking.
Yes.
Yeah. By allotting, we can.
Yeah, generally we can say a couple of.
No, it was a good presentation from both sides.
Yes.
No problem about that.
Yes, they've. Of course, they'll have to hone up some of their skills. Like, when questions are being asked, you should try to answer it in the way possible, in the way and then in more elaborate detail, the co-counsel will. It's one thing, you should not simply pass it on to the co-counsel when questions are asked. Otherwise, of course, also with regard to facts, you can be generally a little more specific. Of course, tough, probably for one side was a little tougher than the other, but you'll have to make up a case. So both the teams have done pretty well. There is no doubt about it. You've done your best. So let us then decide. We will get together and decide who's maybe slightly better. Winner or loser doesn't matter. The participation, I think,
Participation
is ultimately
important.
very, very important for all those who participated. This is my message. Yes. Thank you.
As a moot court participant, I have participated in many moots, but even I have not had the 6 judges together in one go. Maximum was 5. So 6 judges all participative and throwing questions at you. I would say all 4 speakers did very well.
Yes.
But as Justice Jayachandran and Justice Daga have pointed out, be more receptive to questions, because once when you answer the question, you are creating an impression in our mind that you're actually taking us through some direction. In fact, we'll be asking a leading question helping you. You answer it, you might probably avoid some uncomfortable questions. Be more confident in terms of the petitioner's team. Be more clear about the case. Mr. Siddharth has asked something. He would have appreciated had you come back and said, sir, this is the point you asked, this is my answer. On the other hand, the other speaker, I appreciate the respondent speaker. She just asked, I told her about the UK Act. She checked it up and she reverted that. I think that's how you have to be a little quicker on, because it's a virtual moot. So you can even check it in your laptop immediately and just come back to me in the rebuttal. But otherwise, both of the teams were very calm, composed. You did the best job. The best team will win, but the other team is equally good to the winning team. So all the best to both of you. I think I leave it to Mr. Simran to probably make some other comments.
I have 2 essential feedbacks for the councils. A, when you folks are putting across your point, why none of you are even referring to your memo? Just take us to the page number and the para number. That would save time for both you and us. You are saying it at length at rocket speed, narrating the same paragraph verbatim. So just cite the paragraphs in your memo, refer to the memo. Second, the backbone of your arguments is supported by the researchers over here. I have a very essential feedback for the researchers. Throughout the moot, I did not notice a single researcher jotting down the questions that the councils are supposed to revert. It is your duty to prompt them in a private chat window what is being asked, which paragraph of the memo covers it, or to share the screen and cite the judgment to support them. Or during the time when the other team is arguing, it is your responsibility to get back to those queries over your jotted down notes so that the councils are well equipped. The researchers play a very, very important role in any of the moot court competitions, trust me, during the course of arguments. Because while facing 6 people altogether, the councils are flustered. They have their own line of argument, and specifically in online mode, it is quite possible that they do not retain what is being asked. They do not follow coherently what is being asked. So it is your responsibility to prompt them immediately, because you are way more better equipped as them with your own online database to support them and prompt them. This is what we do when we engage seniors as well. In real practice, we literally cling on to the gowns of the senior counsels to put across the client's point, sometimes shamelessly before the bench as well. So we be very well equipped with that particular point, because else the entire line of articulation fails before the judges. Not once, but twice. So that is all I have to say. But brilliant work by both the teams. Specifically, team 1, we've been putting forth a lot of questions to you. You have somehow maintained your composure and continued with your line of argument. Well done.
Thank you so much, Your Lordship and Ladyship, for your valuable feedback and for being here with us by taking out time from your busy schedule.
Just find out, one second, ma'am. Just find out if anybody else wanted to make a comment. Ms. Brar or...
I think they're covered, and I would just supplement on the researcher point, because the researcher is, I mean, very, very critical. And like Mr. Naik said, that even in court tomorrow, you would be, if you're an assisting counsel, the arguing counsel really relies on you to have quick answers and jot down. I mean, I think because of technology, a lot of students don't tend to do that, but writing it down quickly, very quickly, the questions, and researching on them and giving them to your arguing counsel would take you far.
The other...
Honorable Justice Jadindra already pointed out that they were actually not quick in responding on several questions. That has been pointed out, but that part, I think, Gradually they will learn, and you all were actually very good. So you all will learn, and you will next time when you participate in the competition, that will be much better. And these suggestions are actually word of wisdom given by you from very experienced persons like Justice Jayachandran and Justice Daga. You see, you will never find this kind of panel. So this kind of panel is very good. And I saw Mr. Murthy, you deserve to be a justice. So you really, you are at wrong place. You are at wrong place. It was very good program. Because initially what happens when you we question immediately, their pace is shaken. So that's what I was observing. But you all actually handled it very well. And you see, the persons like Murthy, if they are there, then you all have to be more vigilant, more you have studious, and you have to prepare your case better. So next time when you see that Mr. Murthy is on the panel, you start working 2-3 days prior to that. And it was very good here. And actually, it's really very nice that you all participated. Participation is very important. And all kind of congratulations, everything to you all that you participated. And even we also get enlightened when we see the word of wisdom of Justice Jayachandran and Justice Daga. It's really very nice to be in the panel, and it's very good. And congratulations to you all for the greater participation. And thank you, Simran. Thank you, Mr. Murthy. And
pleasure, sir. Very kind words for you. Pleasure sharing with you.
Thank you.
Pleasure sharing with you. And
You want to?
I think me and Vivek would be the Siddharth would be the youngest. I think Siddharth is the youngest, followed by me.
Siddharth is there, but you deserve on the other side. So now we are going to appoint you directly.
You want to?
Sir,
you want to punish him by making him as a judge.
Sir, Pradeep sir, I'll better come and join with you there in Delhi. We will probably be there than coming on the other side, because I think.
Please come, but at least the collegium of this law internships, we have now appointed you. So you have.
Thank you. Very kind.
Thank you so much.
Yeah. Yes, my court officer.
Thank you so much, sir. I would like to thank you, Your Lordship and Ladyship, for your presence by taking out time from your busy schedule and judging the teams. We are overwhelmed to have you, sir and ma'am, with us today. We will again get back to you soon in the future. Thank you so much for your presence in this competition. All the participants of the teams now can leave. We will declare the results very shortly. All the best to everyone.